everyone, and welcome to the Legal Talk Show, proudly brought to you by Say What. Today we will be discussing on the age of consent, which was recently increased from 16 to 18 years by the Constitutional Court of Zimbabwe. Now, joining me are two very powerful people, and I will give them the time to introduce themselves, starting with the lady to my right. I'm sorry, I'm a bit biased with the ladies first since I'm a lady, so maybe you can start by introducing yourself.
Thank you very much. I'm Philip Mchemwa, the Senior Programs Lawyer for Legal Resources Foundation, Harare. Thank you for inviting me to this show.
Thank you for joining us, sir.
My name is Victor Chirimota, and I'm a child rights practitioner with Mudio Foundation.
All right, so maybe just to give a brief background for those who do not know what we are talking about, on the 24th of May 2022, the Zimbabwean Constitutional Court raised the age of consent from 16 to 18 years in a landmark ruling which might have far-reaching consequences. In 2016, the Court outlawed child marriages and struck off the statute section of the Marriage Act, which for many years has allowed children under the age of 18 to formally get married. The 2022 Constitutional Court ruling has divided the citizenry opinions during, including civil society organizations, who fear that the ruling might indirectly and directly impact young people's access to sexual and reproductive health services. Now, maybe just to start off with a general question, can we get a background to which the ruling was made? Maybe starting with you, sir. What led to the ruling being made from changing the age of consent from 16 to 18?
All right, so it was an application that was made. The applicants were arguing that, the age of consent as it is at 16 is actually a violation of especially girls' rights, as it affects their access to education, to health and everything, also in as much as it is also, party to the promotion of child marriages. Okay. So maybe just as a starting point, that's where we are coming from with this, yeah.
All right. And maybe I'll address this question to you, ma'am. In your own perspective, is the ruling justifiable with the current situation that we have in Zimbabwe? Can we justify the ruling and say, okay, this is the right step in social development?
Thank you very much. Let me start off by indicating that there was a conflict that existed between our Criminal Codification Act, which set the age of consent to sexual intercourse for all children at 16, whilst at the same time we have a constitution which set the age of marriage at 18 years. Mm-hmm. Okay. So that was actually posing problems, especially for teenagers who have sexual intercourse and maybe get pregnant before they turn 18, but at the same time they could not get married. So in reality, it posed a challenge to the guardians of those children, to the girl child in particular, who when they get pregnant, they could not marry. So in my opinion, that judgment was really justified.
And maybe I'll also throw this question to you, sir. Do you feel that it's justifiable?
As far as it addresses the legal vacuum,
yes,
definitely it is. But the reality of it is it's very divorced from the day-to-day interactions of adolescents.
Okay.
If one has consent to sexual intercourse, it does not necessarily translate to consent to marriage. Sex can be had outside the confines of marriage. Mm-hmm. But it's a discussion that the generality of Zimbabwe is not ready to have, that children generally have sex,
yes.
If one is pregnant, it should not also translate to marriage. Mm-hmm. I think this is where we have the term unwanted pregnancies, right or wrong, whatever discourse. So legally speaking, yes, there's merit to the case, but the reality on the ground is a very different far cry.
Okay, maybe a follow-up to that question. What then are the implications? Because we have 2,000 engaging in sexual activities, mm-hmm. and we can't run away from that fact. So what then happens when a 15-year-old has sex with a 16-year-old? Do we throw them in prison? How do we address the situation? Maybe you can start with you, ma'am.
Well, at the present moment, for all those who have gone through the judgment itself, I think the Minister of Justice responsible for the crafting of these laws and the amendments has been given 12 months to attend to that amendment. So currently, as we speak, the age of consent is still at 16 legally from the statutes that are in existence. But after 12 months, the age of consent will be at 18 years.
Okay.
So currently, if a child at 16 years consents to sexual intercourse, that doesn't affect the fact that they've had sex at 16, and really no one can be held accountable for that, because that's the law that is in existence. Even if the Codification Act has been amended, say after the 12 months period, I'm still of the view that that will still continue to pose a challenge, like what my brother has said there, because children always engage in sexual activities. So really, raising the age of consent to 18 years may not really, address the challenge that we have on the ground of children that are indulging in sexual intercourse.
Okay, maybe you might want to add on to what she said.
Indeed, I would say, consensual sex among adolescents is a reality. I think it's a very different case where there's no consent and it's an issue of rape and everything. That is a very different, ballgame. However, when two adolescents are consenting, who are we criminalizing in the end? And I think these are things that we need to consider, or even that the parliament, the lawmakers need to consider in crafting this new law. What are we saying about that? Because there's still a vacuum. What happens when adolescents have sex? Of course, it's right now, if it's at 16, it's consensual, but there are all these other presumptions that existed before about a 14-year-old having sex, and do they have consent, do they not have consent? But what does it mean in the grand scheme? What are we saying now? We're saying children below the age of 18 are completely asexual up until they turn 18 years, going forward. Are we saying that children have evolving criminal capacity, intellectual capacity, but no evolving sexual capacity? Like, what exactly are we saying? So I think these are just interesting dynamics that this judgment has brought.
Powerful discussion indeed. Yes?
Just in addition to that, currently if someone who is below the age of 16 years and another who is also below the age of 16 years have sexual intercourse, that case is actually treated as, an act between children who are experimenting. They are not necessarily charged and convicted for committing a crime.
Okay.
That's the current position.
All right.
So perhaps they are also going to adopt that position to say if someone is below the age of 18 indulges in sexual intercourse with someone who is also below the age of 18, then both of them may be treated as teenagers who are just experimenting.
Romeo and Juliet,
yes.
Romeo and Juliet,
That's offense.
All right, this has been such a powerful conversation. I am personally learning a lot, and I have a lot to digest, and I'm pretty sure we all have a lot to digest. Therefore, we're taking a quick break. Do stay with us. Welcome back to our legal talk show, proudly brought to you by Say What. We are live at the studio of choice, and I am joined in the studio by our SRH defenders. Now, you have been listening to the conversation so far. We have been talking about this issue, 16 to 18. Is it justifiable? What are the pros and cons of the decision? What really is your perspective as young people? Maybe you have questions that you'd like to throw at the panelists. So, this is the time. Yes, we'll start with you. Maybe you can start by telling us your name, and then you can ask your question.
Thank you, Chido. I'm Ashley Nyati.
Okay.
So my question is, we have done a lot, right, in advocacy spaces to try and destigmatize service provision for young people, particularly sexual and reproductive health services, right? Are we not taking one step forward and two steps backwards? Like, is it not going to affect the uptake of services in young people when we're now saying the age of consent is 18 and it spreads like a wildfire? Now, are we not going to have 14-year-olds feeling stigmatized, feeling scared to go to the clinic? Is that not going to affect service provision?
I would say, before the ruling, a lot of adolescents were already facing challenges anyway. in accessing these services. And the effective uptake of HR services is really linked to an enabling legal environment. Ultimately, if the legal environment impedes, the young people from accessing the services, we'll end up having a lot of backdoor services which are detrimental to the rights and best interests of children. So talk of your illegal and safe abortions, because abortion anyway is a difficult thing to get in Zimbabwe. But also talk about your screening for STIs and everything for children younger than 18. Right now, children younger than 16 are already facing challenges. But think about it now that it's going to be essentially all children up until they turn 17 years, 11 months, and 29 days, and then suddenly now they can access these SIX services. So I would agree, in a way, it really is one step forward, with all these policies, we've lobbied and everything, but in terms of the space to take up these services, that space is slowly shrinking, in my view.
Okay.
Well, in my opinion, I'm sure the judgment is meant to curb or reduce the abuse of especially the girl child by older men in the name of consent to sex. That's what I think the judgment entails. It doesn't prevent the girl child from continuing to take, sexual reproductive pills or anything to prevent any sorts of STIs or pregnancies and so forth. So basically, what I'm saying is the judgment is just there to reduce the rate at which the girl child was being abused by older men. So the pegging of the age of consent at 18 has got nothing to do with the uptake of services towards the protection of, sexual reproductive health issues for the girl children.
I want to disagree, I'm so respectfully. I think consent on its own is not just one-sided. There are multiple aspects to consent.
Yes.
This is why we're tying this age of consent to sex with age of consent to marriage, and in the same way, the two are also tied to age of consent to SIX services. They're very interrelated. Because once one has the ability to consent to sex, they must also, have the ability to consent to services that are attached to them having the sex in the first place.
Yes.
So now, when you're at the age of consent, I understand definitely the intention of the court. It is a very good intention. Children must be protected from sexual, exploitation and everything. But there are a lot of unintended consequences, and access to SIX services is one of those unintended consequences if you're not careful about the crafting of this new law.
Yeah, I think I agree with you. There's a lot of thin lines.
Yeah.
And if those aren't addressed, I think we'll continue having this situation of one step forward, two steps back, like she said. So, yeah, maybe, yes?
Yeah, so my question is, so I think, like has been said, what is happening is that we are criminalizing just, having sex is for anyone who is below the age of 18. So my question is, with regards to us as service providers and defenders and advocates and things like that, what does it also mean with regards to trying to provide services to kids who are under 18? Because I think what we recently saw on Twitter was a lady who got arrested because she was selling sex toys to kids, and it was saying she's teaching kids sex or exposing kids to pornography and things like that. So I think also in an environment where kids under 18 cannot consent to sex, and then we are trying to provide services to those kids who, legally speaking, are not allowed to do that. What would that mean for us? Are we not also breaking the law? Are we not violating whatever new law has been said? That we're not going to be safe by exposing kids to pornography and sex at a very young age?
Okay, I mean, I don't think selling sex toys is part of SIX service provision, but I get the general spirit of the question you're asking, and it is my view that we need to have empowering provisions within our law that allow SIX service providers to provide these services, because right now, it's in one line, in one policy that sort of allows medical practitioners to give these services. There's nothing expressed in our law that gives such provision service providers that power to give these sort of services. And it would be good, maybe in the crafting of these laws to also give that ability to service providers. But obviously, I think, given the example that you've given, within the confines of what is in the best interest of children, because ultimately, below the age of 18, we're dealing with children, and the best interest should always be of paramount importance. Yeah.
Okay.
Well, from a legal perspective, in my understanding, for as long as it is a child, that child doesn't have the capacity to consent to anything, even to access the sexual reproductive health, you know,
services
on your own.
Yeah.
They need the consent of their guardian or their parent to at least, you know, even sign for those pills, sign for the condoms and everything. So there's really no law which empowers the child to access those services on their own without the consent of the parent or the guardian. So that's where the challenge is.
I mean, ultimately, sex is had in private. I don't want my mother to know that I'm having sex. And I don't want my father involved in me accessing condoms and contraceptives and everything. So really, honestly, why are we giving children the one right on one hand, and then on the other hand, we involve the parents in them exercising their right? If they want to have sex, then if it's within the confines of the law, then they should have the sex. And if they want services associated with the sex, then those services should be readily available. You know, without having to come in with a parent. Because the problem with that is it deters children from accessing the service in the first place. If you think of that in the context of HIV, in the context of STIs, you know, this is why we have a very high prevalence among adolescents, because on one hand, the child is an STI. Do they really want to go to their mother and say, and I maronda, and I need these services? So in the end, they end up just suffering in silence.
Yeah, that's very true. I know for our generation, we suffer in silence. It's not a comfortable conversation that I can have and say, mama, I indulged in sex and I don't feel right. Because you know, either you're going to get whooped or you're going to get whooped. And then she will assist you, but after having whooped you. So it's a difficult conversation to have, definitely. Any other question? Yes?
Yeah, so my question goes with the custom.
Okay.
Is this new bill that we have implemented addressing the custom? Because when we look at stuff like there's what they call the religion, right? They have their customs to religion. They're like, especially, let's look at Mapostori. They usually indulge in these child marriages, these early child marriages. So is the bill really going to address that? Because as we can see, even if the constitution says, the constitution was saying that the age of consent is 18, and then those bills that they were saying that the age of consent is 16. But then we find out that those child marriages were still there. So is there anything that can be done to address that? Or is the new bill that has been implemented addressing that?
So the question is the new bill addressing issues of religion and, you know,
in line with the...
I mean, the judgment, legally speaking, just says, okay, age of consent is now 18. But like I said, there are a lot of these other, you know, unintended consequences that we need to think about, you know, at the back of it. So what does this mean? In religious circles, I found a lot of people were celebrating this to say, no, it's a good thing and everything. Yeah, no sex before marriage, it's a sin and all that. And I was trying to find the verse within the Bible anyway that calls it a sin, but that's a separate discussion, I guess. But no, ultimately, we can't legislate religion and morals. So we can't make it the responsibility of the state to teach, you know, children the morals that we want them to have. That is what you need to do at family level, at individual level, you know. When child marriage is happening, they're still happening right now, even with the new marriage bill, they still are. Yeah. Where's the gap? The gap is in the implementation of the law. So that is what we need to address.
So maybe I have a question as well. Is it safe to say that the nitty-gritties of the bill haven't been ironed out? Like, for now, we know the age of consent has been changed from 16 to 18. But the finer details, what happens when this and this happens, can we fully say they've been ironed out, or it's still at ground level where we're saying, really, it's now from 16 to 18?
Maybe I could just come to that.
Yes.
It's no longer a bill, the marriage it's now an act.
It's an act, yeah.
It's now in the Marriage Act, Chapter 5.15. It's quite specific in terms of indications to the effect that no religion nor a belief shall be justification for a marriage to anyone who is below 18 years.
Okay.
So I think it will come a long way, maybe in addressing issues of, you know, those religions who indulge in child marriages. But of course, we know there's going to be a lot of awareness raising that may be required to those religions and customary beliefs, of course, to keep the rate at which child marriages were going on. Yeah.
Okay, do we have any more questions? Yes.
Okay, so though this debate, is influenced by societal and cultural norms that are there, right? But then at the end of the day, I think we have to come to an agreement that adolescents and young people are indulging in sex before the age of 18, most of them. And so, is it not possible for us to provide at least sexuality education to these youngsters? And because we know they are indulging into sex and it's a reality, is it possible for us to be providing sexuality education to them so that they make informed decisions at the end of the day? Because some of them are indulging. So at the end of the day, they need to know the consequences at least, and also how to use maybe condoms at the end of the day.
The interesting thing about your question is when you read the judgment, the justices themselves, they acknowledge the fact that adolescents are indulging in sexual intercourse. And I even read, I think it's in S. Masuku quite recently. I mean, it's in sort of an old case, 2015. But I mean, even then, the justice, they even said, you know what, it's about 66% of adolescents in Zimbabwe we engage in consensual sexual intercourse, unprotected, that is. I mean, they're not my words, I'm just quoting from judgments and everything. It's what the court says.
Okay.
So the thing with that is, there's always a challenge when you have a law that is divorced from the reality, because if we acknowledge it, it's true, it's happening, then what can we do about that? Sexuality education, in my view, is very important. Children need to have the correct information, so that they can make informed decisions. I mean, it has always been there in one form or the other. I was in primary school a long time ago anyway, and even then we had a section on HIV and AIDS, because I think then it was still, I mean, it's topical right now, but in the early 2000s, HIV was still, at its peak, I would say. And even then, there was all this information about how to use a condom. We were in primary school, so we grew up knowing that there's condoms and everything, Maybe not how to use one, but at least we knew. We knew about the availability of these things. And I think that sort of education should continue, because at the end of the day, the message on abstinence has not yielded much result anyway, obviously, because we wouldn't be having this conversation in the first place. So what can we do now in light of the reality that children are not abstaining, they actually are having sexual intercourse? Sexuality education is important, and also so are SRX services. The uptake of those services is also important if we are going to maybe accelerate our efforts towards an AIDS-free generation, which is, I think, for me, a priority at the moment.
Yes, and I think I agree with you, because if we put a pause on giving these services and providing sexual education, on your max, 18 and they don't have the guidance there in respect of sexual and reproductive health. So any other questions from our defenders? Maybe yes.
Well, kind of learns from what you say. But this amendment is there to protect the girl child, right? Maybe from intergenerational relationships, right? So you once said in years vana below the age of consent tinomatima experiment and so can I take an experiment tiri vana vadiki tinororana?
It's unfortunate you cannot marry. But that's the position of the law.
Okay.
Yeah.
I thought you could
No. The age of marriage says something else, but this experimental thing between teenagers below the age of consent is treated as mahumbwe. Okay. Yes.
But maumbu are rules and mumbu. But anyway, let's because for me, like I say, for me, sex should not lead to marriage. People can have sex outside the confines of marriage. I know it's not a popular view. However, that's what's happening. People are having sex outside the confines of marriage. And we need to separate those two. institutions. There's sexual intercourse, and then there's consent to marriage. So the fact that one is pregnant doesn't mean they've consented to sexual intercourse. Of course, yes, to marriage, So, of course, on one hand, we have all these discussions around child marriages, but I think the correct term should be child early and forced marriages. Because sometimes a child is pregnant, and then because one in Mumbu, I did right. But look, I don't want to marry that guy. We had sex, fair and fine, but it should not lead to marriage.
Marriage, yeah. And I wanted to ask a question. I'm laughing in my mind because I know it's going to sound very weird, but mahumbu wacho kana unakarambashita mahumbu toita say like vakurambachi experimenta before the age of 18. How do you feel we can address that particular issue? Because I am mahumbu apere and agaranga achitwa before the shift from 16 to 18. So maybe how can we address that? Do we say no, kana experimenta kawanzva kwana, don't even experiment at all asichungoziva kuti there's sex? How can we address that?
You know what? The challenge that we might have is that the position of the law is kind of rigid. It's not flexible enough to cover all situations where children may still continue to indulge in these sexual activities and still continue to be treated as, mahumbwe until they get to the age of majority. So that's where we are. We have a challenge.
Yeah. That's very true. Maybe the last question, yes.
I just want to capitalize on their presence here, right? We've been battling child marriages for a very long time. We've been aware that they're there. And it's suddenly why now? What did you guys do right? And also at the same time, is this a good time to now push for other topical issues like abortion services and things like that? Is there some cracks that we can exploit to get more from these policymakers?
Good question. Really good question.
The law is interesting in that based on how you interpret it, you can always find your loophole. That's a secret. Based on how you read it, and because there's nothing that's airtight anyway under the sun. There's always something where you can find. But look, these provisions, I can challenge them in one or two ways. I think it's high time we start having, first of all, honest conversations around abortion services and around the effects of all these unsafe abortions. And it's also high time we maybe rethink our stance, towards the availability of these services in light of what we've seen. The statistics are there for many people, how many girls die in a year from unsafe abortions, how many of them have all these lifelong complications and everything. I think maybe we need to sit down like we did right now and then talk honestly, because a lot of people who afford these services are flying their children to South Africa and everywhere else to get these services, but it is especially anti-poor. It is the people who are poor, who are in poverty, who can't access these services from, let's say a hospital and everything, but with detrimental effects to their health and also even generationally speaking. It is multi-generational, the challenges that it poses. We're in a good direction, yes, but we should find the loopholes and manipulate them, definitely.
Yeah, let me also say that in terms of the Termination of Pregnancy Act, where a child gets impregnated through rape, that's the only situation in terms of which the pregnancy can be terminated. If the pregnancy comes as a result of consensual sexual intercourse, then the pregnancy cannot be terminated because there was consent to sex. So perhaps it will be a question of working around, amending the Termination of Pregnancy Act so that it also includes even, pregnancies resulting from consensual sexual intercourse.
I think this whole abortion topic is a really tight one for another day, but thank you so much for posing the question. If there aren't any more questions, thank you so much, defenders. Nebas. Thank you so much for joining us. We'll take a quick break. We'll be with you shortly. Welcome back, viewers. This discussion has been very enlightening. personally for me, and I'm pretty sure my SRH defenders have a lot of work to do after having heard all of the points and suggestions and debates that we made. But maybe in a nutshell, I can ask this basic question: what next? What needs to be done? What do we need to address? What legal frameworks need to be sorted out for this change, this drift to actually be as effective as it should be? Maybe I'll start with you.
You know, there are no easy answers to difficult questions.
Yeah.
And the question you've asked is, you know, in the category of something that's difficult.
Yeah.
But I would say, in light of the realities around adolescent sexual activity and also the access to services, maybe we need to rethink the law around that, first of all. Right now it says you can only access the service at 18, but is it realistic? Mm-hmm. And whose interest is it serving? And that's one thing that we need to ask and maybe challenge, you know, given the correct information and everything going forward. So I think for me that would be, you know, a good starting point.
All right, thank you, ma'am.
For me, I think we just have to work with what we have at the present moment. Yes, of course, whilst at the same time pushing for the parliamentarians to visit some of the gaps in the law. In view of the Marriages Act, which was recently introduced, I think it would be best to do a lot of awareness raising for the girl child to become aware that if they are to indulge in sexual intercourse and then they get pregnant, they will not be able to be married. For the perpetrators of these crimes, I know sometimes they may be well advanced in terms of, you know, the knowledge, well advanced more than this child that they are abusing. So it's for us CSOs to, you know, do complementary work and educate the girl child so that they just abstain from having sexual intercourse, because it's the root cause of all these debates that we are having here. So for me, abstinence is the best solution until they get to the age of 18 years.
I think maybe just imparting maybe how practical is abstinence in this generation. Like I said, you know, the judgment in Ace versus Masuku, the justice said, you know, of course there's been a lot of effort, you know, around abstinence, and I like how she said, which obviously is not working. You know, it's a given fact, given what we see on a day-to-day. So yes, I mean, we can preach abstinence, but we're not preaching to the converted already. They failed to abstain already, so what's the way forward?
Yeah. Now you pose the difficult question now. But anyway.
But for me, the fact that the age of consent is being raised to 18, the Marriage Act has actually given, you know, that capacity for the police to arrest the perpetrator. Previously, there was no such law. That's why you see, you know, people who impregnated girls would just walk free without being charged, because there was no express law which specifically provided that if a man above the age of 18 had impregnated someone, say below the age of 16 years, then they could get arrested for having that consensual sexual intercourse. There was no express provision in the law. But now that it's there, I think we are moving in the right direction, because at least the police can actually effect an arrest on that person who has consensual sexual intercourse with someone below the age of 18. It has been criminalized.
And what about the girl who's been part of that sex and was pregnant and needs services or got an STI? Again, that gap is still there. We applaud the lawmakers for that empowering provision. People should be arrested, definitely.
Course.
But
I agree with you there. Of course, they would need their parents to take them to the clinic for treatment and so forth. They cannot just go there alone. So I think somehow we need to address that.
We do.
So I think it's safe to say we have the skeleton. It's there. Now we need to put the flesh.
Definitely.
Exactly.
We need to put in the work. We need to join forces with the legal sector, the CSOs, the community even, and make sure that it's a full functioning thing, it's well oiled, such that we don't have so many loopholes that then lead to us asking, what about this? I mean, the law is saying yes, but in a way it's contradicting this and that, so how do we adjust this? So I think this discussion was a really necessary one, and for those who are watching, especially those who can assist us in putting the flesh in the skeleton, Martin's Gual. We believe Martin's Gual. Thank you so much for joining us. To my SRS defenders, thank you so much for joining us in the studio. This has been another episode of the Legal Talk Show, brought to you by Say What at the studio of choice. Signing out.